Hello friends, in the series on the income tax cases, today we will discuss a very important issue, and the issue before the Delhi ITAT F bench in the present case was that if the notice is issued in the name of a dead person and after the issue of the notice, if the legal heirs informs the revenue that the assessee has died, so in that cases what will be the fate of those notices and the assessments which have been completed in the name of a dead person after informing the revenue by the legal heirs that the assessee is dead, and if the revenue has not issued the notice to the legal heirs separately in the name of the legal heirs. This issue has been taken up by Delhi ITAT F bench in the case of Deputy Commissioner of Income Tax versus Pranav Gupta, and this case is reported in 125 ITR Tribunal Short Notes 13. The date of the judgment is 20th June 2025. The facts of the case are like this. In the present case, an assessee was dead. After his death, the notice was issued under section 148. When the son of the assessee received this notice, he informed the revenue that the assessee is no more and hence the proceedings should be dropped. When the son of the assessee informed the revenue, even after informing, the income tax department didn't issue the fresh notice into the name of the legal heir, but continued that proceedings and insisted the son of the assessee to file the return of income of the assessee. The son of the assessee filed the return of income and once again requested that these proceedings are not valid, so these proceedings should be dropped. But in spite of that, the assessing officer passed the assessment order in name of the dead person. The assessee challenged this assessment before the CIT appeal, and the CIT appeal fortunately allowed the appeal of the assessee. So the revenue was before the tribunal. When this matter was before the tribunal by analyzing the section 159 says that first of all, section 159 subsection 2 makes a specific reference to the reassessment proceedings under section 147. There are two parts of section 159. First is section 159 subsection 2 clause A, in which the proceedings against an assessee has already started and after that his death happens. In that case, that proceedings will continue against the legal heirs of the assessee. There is no dispute about that. The second is that if the assessee is dead and the revenue wants to take the assessment proceedings, then they have to take the proceedings in the name of the legal heirs. But there is a third category which is not specifically mentioned in section 159 subsection 2, that is when the notice is issued in the name of a dead person, that is after his death, and the legal heir specifically comes forward and says that the assessee is no more and the assessment proceeding should be dropped. So this is a case which is different from section 159 subsection 2 clause A, because in that case the notice was already issued when the assessee was alive and hence the proceedings were continuing. But this was the case when the assessee has died. So in that case the tribunal said that first of all, it is not the duty of the legal heirs to inform the revenue about the death of the assessee. Secondly, the tribunal said that in case the assessee dies and the revenue issues the notice after his death and the revenue comes to know that the assessee has died, so in that case for a valid proceedings, it is necessary for the revenue to issue the notice under section 148 separately to the legal heirs, and that too in the time limit which is given under section 149. If that is not done, then any assessment made on the basis of a notice which is issued in the name of a dead person and then separate notice is not issued to the legal heir of the assessee, then that proceedings will be null and void. This was the crux of this case. At the end of this video, once again, I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Pranav Gupta, and this case is reported in 125 ITR Tribunal Short Notes 13, and the date of the judgment is 28th June 2025. Thank you, friends.